Yeah, Kavita ma'am, you can go ahead.
I request everyone to settle down, please. We will be starting this post-lunch session. So good afternoon, everyone. Welcome to the post-lunch session. We will begin the session by a talk on collaboration agreements. Our speaker for today is Mr. Nihal Kothari. He is an associate partner with LegaLogic. He comes with more than 15 years of corporate exposure with extensive experience in technology and corporate law. He leads various teams at LegaLogic Consulting in Pune, specializing in data protection and privacy, technology, international commercial laws, software non-compliance, and global commercial contracts. With this very brief introduction, I request him to address this forum.
Hi. Yeah, I'm good. I'm audible.
Come here. Yeah.
So video is here. Okay.
I hope my mic is working. Or it's still not.
Yes, you're audible.
Yeah, but the mic is
Right now.
Yeah, I hope I'm audible now. The mic is still not working. Oh. Okay.
Is working.
Hello.
Okay, I'll just increase the volume from there.
Yeah, I think there's no need of
Okay, so I think I have a tough job. We had a good meal today, and I hope you all enjoyed the Maharashtrian delicacy, modaks. If you're not familiar, I hope you've had one today. At least I enjoyed that food. So this is Nihal, and thanks Dr. Premnath and Dr. Venture Center for having me here. I keep coming here. I just try and find an opportunity to be here, and he gives me that opportunity to present my views sometimes. So today we're going to talk about one very interesting topic, which is the collaboration agreements and the nuts and bolts of the collaboration agreement. And before I start, I'm just going to share it with you, the perspective from where I'm going to address this session. So I work for a firm called as LegaLogic Consulting. It's a full service law firm. We are located in Pune. We are based out of Pune. And I lead a couple of practice areas. One of the practice areas that I lead is commercial contracts team, where on a day-to-day basis for last 10 years, we review, we negotiate all sort of commercial contracts. We draft agreements. We're part of different deals. There are different set of complexities that we handle on the licensing, on the services side, etc. Now, the reason why I'm sharing this with all of you is as a commercial lawyer or as a commercial attorney, when we interact with these deals, we get to see great success stories of the companies. We're part of their growth journey, but we also see some of the companies who have not done really well because they have had to sign agreements which were onerous in nature. And I'm more specifically talking about collaboration agreements. So using my experience of dealing with these different entities and our experiences of working with all of these entities very closely, I have picked up a couple of topics for you. Again, we will be only talking about some good examples. And then I have picked up some principal concepts that I think all of you must know, even though some of those would sound a little theoretical to you in nature. But these are critical legal concepts, which you will find as a part of every collaboration engagement that you see that is happening right now in any part of the world. I do have some use cases for your consideration also that I have picked up that we are going to discuss in detail. Now, the earlier topics that we did, and I had one session already with Venture Center on collaboration agreement. We had not kept the question answers. And again, I propose that we should have it today as a part of this, where at any point in time, let's make this little more collaborative in nature, interactive in nature. So feel free to, at the end of each slide, you are going to get an opportunity to ask questions. And let's make this interactive.
Once you're on that screen, it should work. Just 1 minute. Yeah. Try this one.
Okay. So as a lawyer, I'm sure lawyers have put in a lot of disclaimers that you may have seen. So I do have a couple of disclaimers for your consideration. This is purely for your academic interest. I'm going to use, and I have used a couple of actual logos of the companies just for you to be able to relate to some of the examples that I'm going to share it with you. But the idea is not to infringe upon anyone's IP. And this is purely an academic, conversation here. This is not to be construed as a legal opinion by any chance. So these are some disclaimers from my side. So let me first start talking about the concept of collaboration. And I want to just open this for everyone. When we talk about collaboration, what are your views? What is the first thing that comes to your mind? Feel free to participate. Let's make this interactive.
Give and take.
Yes, yes. So there is a give and take. What else? Sorry?
Identifying the need.
Exactly.
Addressing them.
Excellent. So, there is a requirement, there is a need, and then how do you address that need? That's the second part. What else? And when you collaborate, is it just a one person, more than two people? How many people can participate? How many companies can collaborate? Is there any upper limit to the collaboration? There is no, but you have to have minimum two people, but two companies, two legal entities. Yeah. So, what you see on your screen is exactly what, we were discussing. It's a combination, or collaboration is always a joint effort by two or more people, where there are joint needs, or there are certain efforts which you put in together. And there has to be a working relationship for a shared goal, or you have got some goal that you determine for yourself, and then you work together to achieve that goal. That's the conceptual understanding about collaboration. Now, I have seen when we talk about collaboration, parties come with different set of qualities, different set of contributions that they have to offer on the table. You could have a partner who has got a good domain knowledge from a particular field, and you could be someone who is a manufacturer, or you could be someone who is an investor in that relationship, or you have got a good market reach, you've got a well-established practice. It could be a combination of both. So domain knowledge, technical know-how, you could be the owner of an IP, you could have certain machinery, infrastructure, or a full setup for that collaborative partner's IP to be sort of implemented on the ground. There could be some proprietary information that you may have, or your partner may have. You use that. We already spoke about market position, capacity, and capital funds. So these are the different parameters that work together for you to look at collaboration as a concept. Now, what are the drivers or the motives behind the collaboration? The first is the pool of resources. So when you collaborate with someone, you get to have certain expertise, you have knowledge, you have technology, you have infrastructure, which otherwise is not possible if you're working individually. So, but if you collaborate, you can leverage those expertise.
So continue, please.
And that's how the pool of resources could make that collaboration, make it work for you. Now, when we talk about innovation, collaboration always fosters innovation. If you have sort of collaborated with an entity who comes from a R&D setup, then collaboration always helps to foster that innovation to a next level. The collective output of those efforts is going to be really amazing because of that. So the way two different people approach the problem solving issues, their styles could be different. That otherwise is not possible if you do it individually. Now, I have seen large deals where the output at many times was uncertain for companies. But I can assure you that if collaboration does not completely eliminate your risk, it at least sort of makes it easier for you to absorb those risks. And I'll give you an example of different large government infrastructure projects where it is one of the requirements that you need to have certain capital. And if you look at many of them, I'm not talking in general, But many of those large infrastructure projects at some point in time go slow. And then you should have some appetite to absorb the commercial impact of those conversations. So if you've collaborated with a partner who's got that capacity to consume those risks, it's easier for you to then reduce your risks, if not eliminate those risks completely. I was part of a deal where one of the large entity into data management and sciences had collaborated with one of the large pharma giants. And with that collaboration, that pharma company could come up with a lot of great products because they did not have that strong R&D arm, which this data sciences company had. Now, this example also sort of exhibits a clear, it's a testimony of the fact that things that you do not possess as a company or as set of individuals, with the collaboration, it is possible that it will open a new set of clients. It could open a new set of geographies for you. It could also open a new distribution channels for you. You could go, so the sky is the limit. So new avenues is one of the great, outcome of collaboration. Scaling, many a times I've seen that companies could scale up to a level that they could not have achieved individually because they had a partner who really supported them to scale up. Now there is this concept of synergetic effect, and it's all about two people coming together or two entities coming together, and they contributing towards a common goal, and what you get is a better output. So synergies and the outputs because of collaborations are very high. I know it's going a little theoretical, so if anyone has to contribute anything in this topic, feel free to ask this question. Brand equity is another great example where if you happen to have collaborated with a partner who's got a good repute, then automatically your brand equity also goes up. And the last, which is the investment, which is one of the most important factors of collaboration, is if you've collaborated with someone who's got a good circle in the investment periphery, or they have access to fundings, then your chances of getting funded, they really go high because of collaboration. Can any one of you share any examples of collaboration that you have been part of or that you have seen firsthand? I would like to just hear some examples. Any examples that you have seen where you were part of some collaborations?
Questions? Any comments? Anybody wants to talk about any collaborations that they have helped put together recently?
Yes, sir.
Yeah.
Our institute, we always look for collaborating with other institutes.
Right.
Try to find complementary skills. For example, one of the products, the medical products that we are developing. So we have the medical device domain, but the material used is like a shape and alloy, on which we have no strength.
Okay.
So we collaborated with the National Aerospace Lab.
Okay.
They are in the aerospace industry. So they know all about the materials, but they don't know how to put it in the. So that's a product which we jointly worked, jointly transferring to an Indian company.
Okay. Thank you.
Any others? Any other collaborations? Anybody wants to comment? Yeah, we have several as well.
Yeah, I think.
But one of the categories, especially which is we are very always find it complex, is those that involve IP rights sharing, right? Those are the ones which make it complicated. So one has to really think about background, foreground, and all of those. So especially two technology developers, and if two parties, both are non-commercial, that's one situation. And another is where one is commercial and one is non-commercial, right?
I think the latter one is relatively still easier because the intent is clear, but the first one is fairly complex.
Yeah, so we are seeing complexity in both, so maybe you can comment on that also.
I'll touch upon that, and I'm going to cover those topics. Let's quickly understand some of the types of collaboration. And again, it's a non-exhaustive list. We've seen many different use cases and examples, but I'm just going to quickly talk about some exemplary use cases for your ready reference. And let me start off with the concept of co-branding. And this is way back in 2000 when Nike and Apple, they had collaborated together, and this was one of the first collaborations. It was a combination of a joint marketing and co-branding effort where one partners actually leverages the goodwill of the other party, and they had come up with something where you could actually track the activities of different use cases of wearable devices. So we are talking about wearable devices, but the first version. And even today, when you look at Nike and Apple, they do have a great collaboration where if you're an athlete, you're wearing certain clothes. Those clothes have got inbuilt technologies created which can track your activities, which is synced with your iPhone and the different applications. So that's how you sort of co-brand together. It's a classic case. The second case is technical collaboration. And I couldn't think of a better example than Suzuki and Toyota. These are one of the largest automotive OEMs that we know of. Now, Suzuki is famous for its compact manufacturing of vehicles. But if you look at Toyota, they have come up with a great EV technology. They're famous for electrifying those technologies where now every other car that you see or you want to see next 5 years on the road is going to be electric vehicle. And Toyota continues to dominate that market. So these two companies in 2017 had signed a collaboration deal, and globally today they have come up with different versions of vehicles which are compact but which has got EVs installed in it, and they're dominating the market because of this collaboration. So this is a great example of technical collaboration, and OEM is just one sector. This is sector agnostic combination example. You'll find technical collaborations in every other sector that you operate in. Now, R&D collaborations, these are fairly common collaborations, and generally I've seen R&D collaborations are signed for two different purposes. The purpose, one of the first examples or the purpose for which R&D collaborations are signed is when there is a social cause. And the second is when it's a purely commercial conversation. Now, the example that I have is Vir and GSK, GSK being one of the pharma giants in the US. They had signed this collaboration agreement with Vir. Vir had this monoclonal antibody platform, and with this collaboration, they had come up with different set of tools to limit the outbreak of COVID-19. And they continue to, eventually, Vir went solo, but Vir continues to pay royalties to GSK. So R&D collaboration, this is one good example that I could think of. Now, when I was doing this research for this session, I stumbled upon this interesting fact from Spain. If you go, I don't know if any one of you have been to Spain. There on all the gas stations, more than 50% of the revenue does not come from the selling of the petroleum or diesel or anything to do with gas. It's all about high-end jewelries, high-end goods, or all those food stalls that you see on those gas stations. So the economy there is also heavily dependent upon those different stores which are there in Spain, which are adjacent to those gas stations. So Repsol is one of the large companies out there who's got a chain of such units or petrol pumps, that what we call it in India, in Spain. They have done an exclusive sort of a tie-up or a collaboration with Burger King, which is the large food chain in burger. And that's how they have been one of the dominant market players as far as Spain is concerned. So that's another classic example of exclusive collaboration. Franchisee agreements or franchisee collaboration, it's one of the fairly known collaboration technique where you pick up a business, you scale that business, you pick up the set of distributors, you bring some uniformity in your services, uniformity in your experience. You have your distribution network, and you start going in the market and appointing the franchises. And there are multiple models: franchisee operated, company owned, company operated, and company owned, so on and so forth. So franchisees are one of the well-known collaboration models. How many of you have heard of BOT models? If you know what is BOT? Sorry? Yes. Right. So it's a build, operate, transfer, and highway is a good example where you give a contract to a large contractor, and what you get is a subsidies or discounts in your overall manufacturing, distribution, etc. And then you get an exclusive contract to run that to recover the investment that you would have done. And eventually you transfer that to the government entity. But nowadays there are a lot of private players who also work on a BOT model, especially the large infrastructure projects that we see in the market. They also run on a BOT model. Consultancy collaborations. If you see on your screen, Capgemini, Accenture, Wipro, TCS, these are fairly large firms that we have in India who are into consultancy space. Now, what do? Is they collaborate with the OEMs and they get an exclusive right or a preferred right to go and implement some of those products. So essentially what they do is they provide certain set of consultancies based services around some sort of a product, either on an exclusive basis, on a preferred basis. If you look at the top three big four, accounting firms in India, even they are one of the system integrators. They do have their own products, or they have done some types with different OEMs to do consultancy around the product. So this is another great avenue for collaboration. Academia and industry collaboration, I don't think I need to talk about it in front of this audience. But if you look at all the top IITs, they have done some collaborations in exchange of two things. One, they do invest in return of some IP that is getting built, or they actually look for some talent in the process. So I have been part of many such deals right now for different IITs and for different academias where the industry leaders have collaborated with different institutes. Most of them do look at those institutes for a good talent or creation of or building of some IP. This is one interesting example, which is of this competition collaboration. These are not very routine or common, but they are going to get common eventually. One is Linux as a platform where IBM, Intel, Red Hat, all of these different competing companies came together to come up with certain set of standards and a platform which could be used for the larger interest. Another example that I stumbled upon is Adidas and Nike, where they came together for something called as a Better Cotton initiative, where they streamlined the sourcing process and how the farming technique should be used when they scale up, and then they source the cotton for the manufacturing. So the Better Cotton had some social cause. Linux, of course, had more of a commercial cause and to bring the parity in the market when we talk about the competition. Smart collaborations. Now, Uber and Spotify is a great example where there is a seamless integration of technologies which is done, where you actually experience and cross-sell into each other's markets. So, example, if you have a Spotify premium subscription, and if you're riding in Uber, then definitely, when you book your Uber, you can actually experience your favorite songs. You can have your playlist integrated with Uber. So that's one example where smart collaborations have happened. Now, the next type is corporate and startup sort of a collaboration. And I think this is fairly common, where you have a large company or a corporate who invest into a startup. Now, what happens is when that investment happens, automatically the doors for that small company to your distribution, to your best practices, your market gets opened. And at the same time, the example that I have on your screen is Colgate when they wanted to enter in India, Colgate Palmolive, and Bombay Shaving Company is a men's grooming product company in India, and they're doing fairly well now. Colgate wanted to test the waters in India as far as men's grooming section in India is concerned, because it's fairly untested market. When we talk about India, we do not have many products as far as men's grooming in India is concerned. So they invested in this company, and they were just trying to test the waters. But in return, Bombay Shaving Company actually had the floodgates of Colgate opened, because they could go to different geographies and territories and do their own cross-selling. So corporate startup strategic types have all of these advantages where you get a lot of different avenues. Now, teaming is another large umbrella of collaborations, and under teaming, you have referral, where I just refer a particular client to you or a prospect to you. Once that prospect gets converted into a client for you, I'm going to get some success-based fees from you. It's a pure referral conversation. I'm not going to be part of the overall sales, after sales, anything to do with the quality of the issues and stuff like that. My job will get over the moment you are able to invoice to your customer. So that's a referral collaboration engagement. White labeling is fairly common, where you take a product from someone, or it could be a service, which is a product enabled services. And then you put your own name or logo, and then you go in the market and you sell it. Now, what happens is the liability associated with anything to do with that product also comes back on your shoulder, because your name is out there. People are going to react to your brand name. So white labeling comes with its own set of responsibilities. Subcontracting is the last fairly common example of collaboration, where two entities come together, they form sort of a consortium, or it's some sort of a partnership arrangement where one of the entity actually takes the contract from the client and then subcontracts that to the partner. So there is a prime contractor and then there is a subcontractor. I hope there are no other questions. If you have, feel free to ask. Now, I don't think I'm competent to talk about license transfer out here in front of this audience. You all come from that heavy background. So I think I'll skip the license and the assignment part from it. Okay.
But yeah, please do it, because that's important for us.
Okay. So legally, when we talk about license versus assignment, there is only one difference, which is the ownership of that IP remains with you. What you give it is just a limited right, either to use it, to commercially exploit it, further to sublicense it, or to create certain derivative works out of what you have given it to the other party in lieu of or in return of certain consideration. I'm also going to talk about cross-licensing in subsequent slides. It could also be a barter where you take one technology and then you give one technology to your partner. So that's a cross-licensing deal. But licensing is a fairly common sort of a collaboration type that you see in the market. Assignment, on the other hand, is completely outright sale or outright purchase of your IP. And there are two parties. One is assigner, who relinquishes the rights and the title in that IP to other party. And then there is an assignee, who is a buyer who receives those rights. So these are the concepts of licensing and assignment collaboration. Now, it could be in the form of some lump sum fees. It could be in the form of some royalty for a volume production, or we call it as a running royalty, or it could be in the form of right to use licenses technology, which is nothing but a cross licensing. And the cross licensing deals are up right now in the market. We see a lot of companies doing barters with each other, where they're integrated with the other's platform, vice versa. So these are the different types of collaborations. Now, I have got one very interesting case study for your consideration. And this is Louvre, France, which is one of the well-known, very famous museum. Now, here what we're discussing is the case study of a museum licensing. So this French museum actually in 2007 licensed its goodwill. I think all of us are known about Madame Tussauds and those different museums or wax museums and stuff like that. But they licensed their goodwill and the name to Abu Dhabi. Abu Dhabi, as you might be aware, they're focusing for the last 10 years more on their tourist industry. They're heavily investing on that. So Abu Dhabi government got a right to actually create one new museum called as the Louvre Abu Dhabi. And there, some of these important and very critical ancient artifacts from the French museum were flown down. So they actually licensed some of those artifacts to be exhibited in Abu Dhabi. So I think this is a very unique, collaboration use case or case study where, and then they also offered to provide certain service in relation to, how do you exhibit, how do you put the artifacts, and stuff like that. And if you look at the royalties that they charged or the license fees, it was $1.3 billion. Are we getting some questions here?
You can go ahead.
Yeah. Now, this is another deal that I was part of. This is one of the Pune-based companies where, on one hand, there was a data research company, and on the other hand, there was this R&D informatics company. So let's call the first company as Company A, and the other company, which is the R&D informatics and life sciences company, as Company B. Now, what the deal was, the Company A actually licensed certain pre-agreed process data on the clinical case studies of cancer. Now, the objective of this entire collaboration was to come up with a customized medication for cancer research. And because the data research company was some sort of a market leader with what they did as far as the cancer space is concerned, and the other entity was an upcoming entity who wanted to establish their own presence in the customized medicine space, they collaborated. We represented Company B, and in no time, I think within just period of 13-14 months, Company B had captured a large amount of, fair bit of a market as far as the customized medicine in the cancer research is concerned. So this is another example where if you do a cross innovation, you could actually scale up to a level where you get that competitive advantage in the market.
How did Company A benefit from this thing?
They licensed that. And then there was also royalty which was paid. So it was a license income royalty sharing sort of a deal. Any questions? Okay, I think I'll now start talking about the actual nuts and bolts of how effectively you can create and draft or review, or you can have a collaboration agreement for yourself. So my first question is, yes, sir.
Yeah, I have one. We are all dealing, our act is a facilitator between the educational institution with the industry. Okay. As for the licensing agreement, as you rightly mentioned, the IP ownership will be with the educational institution. And to practice the know-how will be with the industry. Let's say once after having that licensing agreement done, after 4 or 5 years, there is a willful infringement by a third party. Okay. I am the owner of the IP. Okay, I have the rights to sue that guy. But I am not that much of vigilant because I am from academic institution. Correct. Okay, I am busy with my research and my classes, having classes regularly. But the ultimate loss will be to the industry. So then I know in the license agreement, the rights also to take the third party to the court to sue that guy. Also, the rights also with the industry. But during the deposition, you are actually owner of that IP. You have that know-how with you. During the deposition, the academia, the academic institution of that person has to deposit themselves in the court of law. True. So this is a little bit conflict. Most of the academia, they don't prefer to be in the line of court because they think it's too complex and we don't want to be. So is there any, because you are from good and your legal practice, is there any point which should keep in our license agreement where we can waiver that academic person from the legal litigation process, from deposition, from other things?
Okay, two things. One is reactive and another is proactive. Let me first talk about proactive measures. See, at any given point in time, when we talk about enforcement of your copyright infringement or anything to do with IP infringement in India is not easy. You have to go through a lot of hurdles and pain. You have to spend a lot of time, go and appear before the courts, do the deposition, and come out of it. And it's a long drawn battle and process. My first advice to you would be, of course, if you happen to be from academia and there is someone who is commercially interested to, utilize your IP, give a power of attorney to that other entity or to a person from there, anybody who is interested to commercialize, and on your behalf they can go and appear. There is no issue. Second is I would highly encourage you to also buy something called as errors and omission insurance. E&O. I'm going to talk about it, but let me quickly talk about it now. Now, what happens is if you have an E&O, the insurance company takes care of all your expenses. Right now, the challenge with academia is the moment there is a claim-like situation, you're stuck there because you're looking at that IP as one of the ways of monetizing it, but the basic motive is to do R&D. But if you're getting stuck with some litigation, then it's difficult for you to then focus on your core energies. So there, having an aid from insurance company also reduces some of the hardships that you're going to go through. This is how I would react to it.
Yeah, because defense part, my expertise is litigation part in IP. That's mandatory. Okay, but in Indian context, that's why I have this knowledge from your side. Is there any overlap from the litigation part? Let's say the infringement has been occurring by jurisdiction of Ahmedabad. Then I can feel the one in Ahmedabad. Okay, and academia is from Northeast side. Okay, for deposition part, okay, let's say I'm talking about patent. You have all the information and everything during deposition, you have to come. Okay, for that time, the academia has to travel to Ahmedabad.
No, see, here it's going to be the other way around. See, it is the academia who's got aggrieved by the action of a third party. Am I correct?
Yeah.
So academia, the cause of action would arise where where exactly that IP was invented, or it was registered, or it is being held by that academia. So if that happened to be from a Northeast, they have got all the rights to go and sue that infringer in Northeast only. Why they need to travel to Ahmedabad in the first place?
Okay.
Yeah. So if you happen to be from that R&D from that institute, and if you come across a situation where somebody else is infringing upon your IP, let's say we are in Pune, you're from Pune, and then you come across somebody knocking off your IP in Ahmedabad, the Pune courts will have exclusive jurisdiction to deal with that matter. By default.
If the product is confiscated in Pune,
Yes.
let's say,
Yeah.
and the IP owner is from Northeast,
It doesn't matter.
then the Northeast IC can file the suit in Northeast.
So what we are discussing is a cause of action.
Okay.
Now, cause of action could happen because you are owner and you're located in Pune. It could happen because there is someone to whom you have licensed, but they are actually trying to commercialize that in some other part of India. And there could be an infringer who is sitting in some other part of the world. So all the three courts can have jurisdiction, but for your convenience, you can go and file it in the place which is convenient to you. And that will reduce some of your hardship, but hardships will still be there. Right.
I think we have one more question online. Sharwari, can you read it out?
Yeah, just give me a minute. Yeah, so Mukund Chaudhary has a question. The context is that they are planning to enter into a pilot collaboration with an Israeli company where they will be helping them pilot a product they have built in the Indian market. Now, the question is, apart from an MOU and NDA, what legal considerations should they be aware of? They're saying that it's a very specific question. Maybe Mr. Nihal will need more details, but they are questioning. The question is that can you help them navigate the design of the MOU also?
Yeah, of course. And again, the concept of MOU, if you look at these terminologies which are used, those are many times they're misnomers. Of course, what I understand, and just to simplify this for the audiences, it's just going to be a handshake agreement where you're going to just agree for some broad level business terms. But the moment the real action happens where you want the other entity to invest into it, you'll have to really go through that entire conversation as to see what are the stakes involved, how much is going to be the investment, do you need some bank securities, what happens when there is a breach, how are you going to remediate that breach, so on and so forth. So it's going to be a full entire thought process that you'll have to apply there to see as to how you are going to mitigate your risks. And then probably we can design something for you. Feel free to reach out to me as a part of this conversation. I'm happy to give you all the guidance that you need.
Nihal, can you comment on the difference between an MOU and a collaboration?
Definitely, that's a great question. when we talk about MOU, generally speaking, these are again, as I was just explaining, these are the broad level concepts and understandings of what you want to objectively achieve at the end of the day. It could just be a problem statement written with a lot of aspirational value. You could sometimes talk about how you're going to achieve it at a broad level, what are going to be the roles and responsibilities, but you not beyond that go further. When we talk about collaboration agreements, these are definitive agreements. You're going to actually spell down to the last mile and detail as to who is going to do what is going to be the consequence of someone breaching their roles and responsibilities, which courts will have jurisdiction, how things will pan out, what happens when the revenues are not being met, if there are certain targets, you're asking for an exclusivity and there are certain targets which are given to you. If you're not able to fulfill, then whether the other party gets a right to exit that conversation and so on and so forth. So the first type, which is the MOU, is just a broad level understanding between the parties. Generally, MOUs do have certain conditions laid down very clearly to say that parties generally give themselves certain time, whether it's 30 days, 60 days, 90 days, to see as to how things are working, whether they are aligned. Because sometimes it's initially too early for them to really decide as to whether the other party has that competency, infrastructure, capacity, market reach, wherewithal to implement certain things, and whether or not there will be a success. So they test each other without investing, or it could be with some minimal investment. But generally, MOUs do not carry any dollar value. The moment you see any MOU with certain numbers written on it, you can very safely assume that it is not an MOU. It is then a definitive agreement. It's like a collaboration agreement at a high level. I hope that answers if you have any. Yeah.
Could you difference MOU and MOA?
MOAs are different. It is more in the context of your compliances. Again, these nomenclatures do not matter. What it matters is whether or not you have got certain set of agreed commercials with breach provisions that you can enforce before a court of law should a breach happens. That's a definitive agreement, and anything else is MOU, headers of terms, or term sheets, etc. The nomenclatures could be different.
Yeah, just 1 minute. The MOA that you are talking about is memorandum of association, right?
Yeah, that's
What
correct.
are you
I was
talking
talking about MOU, memorandum of understanding, and memorandum of agreement.
Memorandum of agreement, I've not come across this as a
But
term.
this I've seen in some government circles. That's why I pointed it out.
Okay, sure.
Yeah, but it's not. It's usually memorandum of understanding or it's an agreement. Right?
Yes.
It's a substantive agreement.
Yes, definitely
Agreement.
agreement.
Just there are rights and responsibilities for each party. Typically, the general understanding is when we use MOU, they take the view that it is more of an intent.
Yes, sir.
Right? It's not very binding per se, or there are really harsh clauses in it, or those kind of things are typically taken.
That's good.
But there are cases where people call the collaboration agreements as MOUs in government circles. So it is.
I think the government contracts work slightly on a different pace altogether. They have their own set of complexities, and it's more customary in nature. And it is fairly understood when you talk about certain terminologies. Those are specific to that sector.
Can you also elaborate a little on the binding nature of MOUs? Can there be clauses such as not disclosure clauses being separately made binding and not the whole MOU?
Yeah, that's a great question. Now,
can you repeat the question?
Yeah, I'll repeat that. And he's asking that question with his legal background, and I appreciate that because it's a very nuanced conversation. So many a times what happens is when two parties are collaborating together and it's a shake hand or a MOU sort of an understanding, you're still sharing some confidential information because you're going to open up with each other, you're going to share your ideas, know-how, wherewithal. There, in the MOU, you could say that only the confidentiality clause will be binding in nature. Everything else is non-binding. So you can have a nuanced way of dealing with it. People go one step further where they say that not just the confidentiality, but certain survival obligations of data that I may have shared will survive in perpetuity because there could be a trade secret. Now, in India and globally across, unlike patents, trade secrets do not get that protection unless you protect those contractually or you really keep those in your custody. And contracts are one of the best techniques to safeguard those trade secrets. You can't register your trade secret. The way you do it is you then contractually bind somebody else from not sharing it with somebody, keep that data confidential. So that's how it happens. So great question. Thank you.
Just one more question.
Yeah.
So, more often than not, we see in academic setups wherein there would be an umbrella MOU that will be executed, and under that there will be certain specific definitive agreements, which also either incorporate the clauses or give effect to the clauses of the umbrella MOU. So in such a case, because of the non-binding nature of the MOU, how would we give effect to the agreement? Should we really include all the clauses or just give reference to the MOU?
Right. I think those umbrella agreements just act as a framework. They do not have a legal binding per se beyond the point, but they act as a guiding principle for you in which direction you need to go. I've seen cases where there were some complexities which got evolved over a period of time, because they had mentioned that if tomorrow there is a conflict between the local agreement versus the umbrella agreement, and the umbrella agreement will supersede. Now the umbrella agreement was not actually a binding agreement in the first place. So I don't think it's a great practice, but it's there customary in many cases where you will still see those being cross-referred, but those are just being cross-referred. Those are not the governing agreements per se. Okay. Okay.
Just as a quick announcement, if anyone wants tea, coffee, you can step out and come back. This is not a formal plate in case you want to carry some tea, coffee.
No, I'm good. I'm good. At least I'm the one who is not sleeping here. Okay, so let's quickly talk about, at a high level, when we talk about JVs, and I'm sure many of you have heard of something called as a joint venture agreement versus collaboration. Now, this terminologies, again, as we were discussing earlier, it could be a misnomer, or those could be used interchangeably. Many a times, when I speak with people, they realize, or they have this perception that when they talk about collaboration, it is always an equity-based collaboration. But if you look at the legal circles, generally speaking, collaborations are being pursued by lawyers as non-equity based collaboration. Of course, there are exceptions where there are equity-based collaboration, but generally speaking, in the commercial contract world, when we talk about collaboration agreements, it's a no string attached approach. Two parties are coming together contractually. There are no stocks involved. There is no shareholding. You purely decide and agree on certain numbers. You define your boundaries, you define the expectations out of that contract, you drop that contract in a way that if there is a breach, what is going to be the output, and that's the collaboration agreement. But if you look at the JVs or a partnership agreement, it's generally called as a spin-off or spin-offs, where you allocate the shares, you allocate the equity stocks, there is an infusion of capital, and depending upon the proportionality of your capital infusion, your ownership is going to be determined by that. Now, when we talk about JVs or partnerships, generally these are there for a long-term game, where you want to get associated with somebody as a partner on a long-term level. You have limited. Hello. I think it's safe. Anyway, so it's yeah. Give me that address. Please go ahead. Yeah. So the flexibility when we talk about the JV or partnership agreement is relatively low, because you're there for a long time. Yeah, but when we talk about collaboration agreements, those are flexible because you're just contractually engaged with someone. You're not married to that entity forever. The risks and rewards are, of course, different. You can contractually decide as to what could be your rewards or what could be your risk, even though you're not taking a lot of risks when you're investing in that particular relationship. The rewards could still be more than the risks. That may not be the case when we talk about JVs or the partnerships. Now, you look at any collaboration agreement, regardless of any sector, any industry, any geography, you will find, and if you just spend 1 minute on this to understand, you will find a common skeleton of any collaboration agreement. You'll have a preamble with an objective. There will be certain key definitions. There will be a scope of that engagement. There will be certain consideration. The ownership aspects will be drawn very clearly. there will be certain legal clauses, and at the end, there will be certain generic clauses. This is a global framework of any collaboration agreement. Yes.
Sorry for the disturbance.
I hope this is so. Now, let me slice and dice some of the key clauses of collaboration agreements for you. And to start off with, we have something called as preambles and recitals. These clauses generally talk about the history of why the parties have come together and what is that they want to achieve together. These clauses could look slightly aspirational in nature, but if you happen to be someone who is negotiating that collaboration agreement, don't use any superlatives. Ensure that the intent of your objective is very clearly written and laid down well. Avoid any sales language. I've seen companies coming together and they write in their collaboration agreement that we want to build a state-of-art facility with XYZ things. Don't do that. Keep it simple, because it lays down the ground for your substantive clauses of the agreement. And tomorrow, if there is a dispute, the courts are going to interpret your preambles and the recitals to see what exactly was the intent. So the toned down language is always preferred, is what I generally recommend to all my clients. Now, let me quickly talk about the legal guardians in any, and if out of this entire session, if some of the concepts that I'm going to now explain it to you, even if they stay with you as an output of this entire session, I think it will be worth an effort. And I'm going to talk about warranties, indemnities, liabilities, and dispute resolution clauses very quickly. Now, one quick question. Is there any difference between a concept of warranty and a guarantee? And I'm sure, some of you must have, what is the difference?
Warranty guarantee is assuring that there can be a modification or you can replace it for something.
Okay.
But a warranty, more or less, like the product itself can be.
So what happens? Achha, so you're connecting that with the replacement. So if there is a guarantee, then there is no replacement. Or there is a replacement.
It can be amended or it can be corrected.
Okay.
More or less. It can be corrected. Whatever the problem, it can correct. That is the interpretation of the guarantee.
Okay. Anybody else who's got a different take? Is there any difference between the concept of warranty and guarantee? Or they are more or less the same?
For me, guarantee is more binding in comparison to warranty. The warranty is not that much of binding.
Okay.
Yeah, like as warranty. Correct.
So actually, guarantee as a concept legally is best understood not in the context of products, but it is understood in the context when you go for a loan. When there is someone who is, signing as your guarantor, right?
Yeah.
So there, that person is actually stepping into your shoes if tomorrow there is a default, there is a bad debt. That's the concept of guarantee. But it's more of a sales exploitation of that term, which has been now used as a part of the products that we buy, where you'll get a guarantee card sometimes, but that's nothing but a warranty, in other words. Now, the only difference is when we talk about warranty and when there is a warranty and then there is a breach of a particular contract. Let's say you've bought you've taken certain services and then you come across certain issues, then that you get the right to claim damages in the form of, either having, you can't just reject those services. You can't just reject that product. First right that you get is to, get that particular product fixed. So legally, you don't get a right to just ask for a refund of money, generally speaking. But what you get is a right to get that particular problem remedied. Now, why I'm explaining all of this is contractually, when you collaborate with someone, you will come across situations where you will be asked to provide certain set of warranties, collaboration agreements. And there it is important for you to understand what is this concept of warranty. So I think we all understand fairly the concept of warranty in the context of products. But if you look at the other types, you giving some sort of a warranty that the products that you would have delivered or the services that you would have delivered are completely defect free. That could be one warranty that you can give or you will be asked to give. In those cases, you have to have a backup to ensure that there is somebody who is going to take care of those issues if tomorrow there is an issue with your services or the product. Infringement. Now, you all have a very strong IT background. When you give certain technology, some product, certain IP to someone, there will be a naturally an ask from the other party that, look, what you're giving it to me is a concept, some idea, some thought, some patent, some technology, some copyright. If tomorrow when I use it, I want to have some sort of a warranty from you that if tomorrow some third party comes after me to say that, look, what you're using actually belongs to me, then that warranty of infringement will get triggered. So that's the concept of infringement warranty. Now, when you deal with, and I think the example that was, the question that was posed online was, if you're dealing with Israeli company or some overseas company where you don't know what the local laws are there, and for that entity to be able to actually do certain manufacturing of certain products, they need certain licenses, they need to comply with certain laws. You could very well ask for warranties of compliance with the laws, where you take a warranty from the other party to say that when you're delivering these goods and services to me, please give me a warranty that you will comply with all the applicable laws. So that's a compliance with the laws warranty. And the last one, which is what happens when you sign a contract with some company where the person who is signing does not have the authority or power to sign that contract. How do you deal with such situations? Have you ever come across situations or ever stumbled upon that question as to whether or not the person who is signing that contract has got that authority or power to sign? Yeah, not power of attorney. Power of attorney is a slightly different concept, but here, let's say you are dealing with me. I'm one of your potential suppliers. You give me a contract, you sign on that contract, and I get that bona fide protection under the law because I would assume that you have got the power. But what happens if you don't have those? Then the legal complications start. So contractually, you could ask for that warranty to say that both the parties, when they're entering into a contract, represent and warrant that they have got full authority and power to execute that contract. So these are some of the different flares of warranties that you could secure.
The full form part of it would be a representation, which is sort of either existing or backdated, that they already have certain authority or they are already complying with certain things.
Yes, that's correct. That's correct.
Yeah, and warranty is more of a futuristic thing.
It could
be sort of.
It could be, yes. Representation is always factual, which is as on date, but warranty could be futuristic in nature.
How do you make sure that the other party is actually authorized?
There is no way you can check that out, and that's why contractually you can at least take that protection from them, so that tomorrow if there is a breach, at least you've got some contract that you can go and enforce it. Otherwise, it's not easy for you to. Sometimes it is possible, but not every time it's going to be possible. So what we're discussing, there are some of the ground situations that you need to tackle locally as to how do you enforce, how do you operationalize that contract.
Which is why in indemnity, you would usually tell if you breach representation or warranty, you would indemnify the other.
I will touch upon indemnity also. Okay, I think I want all your full attention on this slide. This is, I think, one of the, and I call it as a heart of any agreement, which is called as a limitation of liability clause. And this is very interesting concept. Please pay full attention. Now, I'll give you one example. You have, and let's take an example where you have agreed to deliver certain products to party B. You're a party A, and you're required to deliver certain products to party B before 31st of May of 2023 or 24. Now, for whatever reasons, there is a delay and there is a ship which is ready, which has been hired by party B, where they're going to just take all your goods and then offload that on that ship. They have invested, they have taken that entire, they have booked the entire freight of that ship for you, and you delay that. Now, you know for sure that if you delay that, and if you agreed for certain date, they're going to suffer clearly certain losses because of that. Now, my question to you is, if they sue you tomorrow, whether you will be able to defend your damages or your loss to a particular amount as low as, let's say, 1 lakh rupees, when the actual losses are worth 1 crore rupees. Is that something legally which is possible? Can you limit your exposure to lawsuit by contractually saying, come what may, if tomorrow you sue me, I'm going to limit my liability to a particular amount. Is that something which is possible? Any thoughts on this? Let me give you another more simplistic example. Let's say you've got a very expensive cloth that you go and you put it with your dry cleaners for washing and stuff like that. That new clothing that you've bought is worth 50,000 rupees. And then tomorrow, for whatever reasons, at the time of delivery, you realize that that entire new set of clothes is completely messed up. It is beyond something that you can wear. Now it's a clear loss of 50,000 rupees for you. But can tomorrow that dry cleaner stand up and say, sorry, ma'am, sorry, sir, my liability is limited to only 1,000 rupees? Is that possible?
It's possible.
How come?
I'm not
Yeah.
this example, but generally it is possible. Because if the damages go beyond the capacity of my monetary capacity, I think I will not be able to pay.
Got it. So the receipt, the chitti parcha that that dry cleaner would have issued to you, if you flip that, generally they'll write there in a very small font which says anything that goes wrong, not more than 1,500 rupees or 300 rupees. That is nothing but the limitation of liability clause. So by law, you are allowed to limit your liability if tomorrow there is a lawsuit between two contractual parties to any number that you think is reasonable. Of course, if it is completely unreasonable, we have seen cases where the courts have actually interpreted it that they have stepped into that conversation and then they have tried to do justice. But generally speaking, globally, the courts would not touch the limitation of liability clause. Now, what it means for you in your collaborations, in your commercial agreements that you enter.
Before a limitation of liability, also in the contracts, can we? I mean, I think we can also incorporate a liability insurance.
Liability insurance. No.
So if there is something going on, infringement, whatever.
I'll cover. I have an insurance slide for this. We'll touch upon that, which is a different insurance work differently than the liability. Liability clause is your ability to shield your exposure to a lawsuit to a particular number. That's all. So if tomorrow you have taken, let's say you're going to manufacture something for someone, that entity has given you certain, of course, there has to be a fair play. You can't just do some fraud and say my liability will get triggered. There are exceptions under the law. If there is a criminal act, if there is a fraudulent act, if you have done something intentionally where the IPC sections are going to get triggered, which is treated as a pure crime in India, then of course the limitation of liability will not apply. But for anything else, which is a civil conversation, when two parties are doing business together, if there is a breach by you, then the liability clause will get triggered and you can you get that immunity and protection of what liability you would have limited under the law. I'll come to the insurance part and we can discuss and you can ask me questions. So we spoke of the concept of liability where you can limit your monetary liability if you're faced with a lawsuit, provided it is mentioned as a part of your contract. And generally it can be a cap. Now, how much should be your cap? That's another large debate that I generally say, and it's heavily negotiated. It could be the total value of your contract. It could be 50%. It could be the total margins that you could make. It is all open for you. Depending upon the volumes which are involved and the exposure that you have, you can limit your liability. I think the last sentence is important. What happens when your contract, your MOU, your collaboration agreement, or the legal agreement that you're signing does not have the liability cap? There is no clause which limits your liability. What is the net output of that? Yes. So I think that's that should be your takeaway, that if you come across a contract where your own contractual liabilities are not capped, then you are signing up for an uncapped liability. So if you're going to earn 10 rupees and if your exposure is 1 crore rupees, you're gone forever because there is no liability cap. There is no liability clause. So, and therefore I generally say that take some legal help, and if you can't take that help, at least Google out yourself as to how the limitation of liability clauses are generally worded and try and identify those in a contract. Otherwise, you are exposed. You are signing up on a blank check when it comes to your legal exposure.
parties collaborating.
Yes.
And in case of a loss, both parties will bear whatever losses they have suffered.
Right.
And put forth no claims on each other.
Right.
Will it take place?
Yes, in a way, because there you're saying if we both suffer losses, then you will at least not come after me. That itself, in a way, acts as a liability clause, but that's very rudimentary way of dealing with the situation. You know, you should look at a more refined way of dealing with those risk resolutions. But yeah.
Just one question.
Yeah.
Here, sorry. So a lot of public funded institutions, because they are funded with the taxpayers' money, they wouldn't go in for an indemnity clause. They're not authorized to give indemnity, and consequently, they will not accept a liability as well.
Yes.
So rather than mentioning that they will not go in for any liability clause, they rather prefer to stay silent on the liability part of the agreement. So in these cases, is there another way to circumvent this and see if some other clause could give effect to it?
No. There is no way. See, it's a binary conversation. Either you have your liability capped or you don't have it. And if you look at the recent Supreme Court judgments, they've also bashed a lot of government entities because by very nature, they don't include those liability clauses, or they don't want the suppliers to have the liability clauses included. But that's how it is. And you're not going to change the entire system. And this is not in India. If you look at the federal contracts, and I have been negotiating federal contracts for a long time, those negotiations are at a very peripheral level. When it comes to liability indemnity, they don't even talk to you. They'll say, sign it as is or leave it. We're not going to give you the contract. It's a simple conversation. But there is no way out for you. And the only way you could possibly look at it is, how do you mitigate your risks tomorrow if there is a breach that happens? I recently came out of one large deal where it was not a deal, it was more of a settlement with one of the government entities or PSUs, and I was representing a private entity. And there, they had not operationalized their responsibilities in a way that there were certain lags over a period of time from that entity. And of course, then the government entity encashed the bank guarantees. They went and they blacklisted that vendor. Then they sued and stuff like that. And we came out clean. We had to negotiate a lot, many things we had to let go. But the crux of the whole issue was they had not operationalized the contract. What happens is we sign a full-blown, well-negotiated agreement and then we forget about it. And then we go to a normal business. We don't really understand what we have signed. And only when there is a situation where you're at a loggerheads with the other party, you go and read your contract. So I do have some tips at the end of this slide I'm going to talk about, but yeah, that's one of the realities that we deal with. So there are two types of damages. This is slightly heavy, but I'll simplify it. Tomorrow, if you have contractually, signed up a deal with me, and I get involved in certain unethical activities because of which your goodwill in the market suffers. It could suffer, right? If you have done a tie-up with someone who's involved in certain things which are ethically wrong, they do something, and in India we've seen different scams, and large names are part of those. Because of that, the other parties also could suffer. Now, if that suffering is related to your goodwill or your share value in the market going down, that's an indirect damage, and by law you cannot claim that. The example that I shared earlier, if there is a delay in the shipment, that delay and the losses as a result of that shipment are direct losses. So limitation of liability will always allow you to recover those to a level of cap. But when we talk about indirect damages, those are completely disclaimed. By law, you cannot recover those. Okay, I think we've been talking about indemnity. And this is very interesting concept. I'm sure all of you are aware about the concept of insurance. When you buy insurance, insurance is nothing but a very sophisticated indemnity contract. What it simply means is, if tomorrow, because of my behavior, my actions, my omissions, if you, who is my collaborative partner, or you as my customer or my supplier, you suffer anything. It could be in the form of a legal lawsuit. There is a demand that comes on you. Some authority takes an actions on you. Anything of that sort, because of my action, then I will step into your shoes and I will compensate you for everything that you may have suffered. That is the simplified concept of indemnity. Indemnities are not mandated by law. Those are something that you will have to contractually negotiate all the time. And it all depends upon what language do you use in your contract when you negotiate indemnities. So it's purely a promise to save somebody from losses that may result as a result of your own conduct. Now, there are two types of claims that could happen. One is I don't perform my services because of which you suffer direct losses. You can ask me for indemnity there directly, where you don't need to prove any losses directly. You just have to show me the bill and say, look, this is what has happened, and I'm using my indemnity protection that you have given it to me. Please step in and just take care of it. But there also could be a third party indemnity where I have given you a license of my software, let's say. You're using it, you've gone in the market, you've started distributing that software, and my competition comes and takes an order from the court and stops you from distributing it. Now you're going to suffer or that competition could also sue you saying, look, how are you distributing my software? This belongs to me. This is a software infringement claim clearly. There, because I would have given you an indemnity, I'll have to step into your shoes and take care of all your losses. So that's the concept of, so it's purely a reimbursement conversation. Now, is that all? Is that what the concept of indemnity means? No. Indemnity also comes with something called as defend and hold harmless protections. Now, defend means you will not just be required to prove that there is a loss, but the moment there is a claim that comes, I will just send you a letter on email saying, look, there is a claim that has come. Please involve your lawyers. I'm not going to spend a single penny on it. And you're going to step into my shoes and take care of everything. So that's a right to defend. And hold harmless is where I also give you a protection that if I get sued, I'm not going to sue you. So, these are some of the concepts of indemnity, but I think the crux of this entire conversation is, A, if you're providing goods and services, if you're a small entity, do not provide indemnity. But if you want to get certain services from someone, or the stakes are very high for you, ask for those indemnities. Now, when the indemnities are given, the important consideration is to whom do you give indemnity? I've seen indemnity clauses worded in a way which says that you will give indemnity not just to me, but to my affiliates, to my investors, to my customers, to my end users. So it goes on and on. So anybody who suffers in that entire chain, I will just step in. So you're acting like an insurance company in that case. Don't do that. Try and give that indemnity only specific to that particular entity. For what instances? Those, when you give indemnity, indemnity has to be for a specific instance. It could be for an IP infringement. It could be for delay or deficiency in services. You can't write something to say that any breach of reps and warranties. I think you mentioned that point. Then you're acting like an insurance company. So try, if ever you are encountered with an indemnity ask in a contract, try and limit that to a specific instance. Try and limit that to a specific geography. If tomorrow there is a claim that comes in India or in Maharashtra, then I will step in. But if it comes in the US, then I can't. Stuff like that. Okay. Have you ever wondered when you deal with overseas entities, how the governing laws apply, which laws to apply? Have you ever encountered with these situations as to how do you deal with those cases? If you're dealing with an Israeli company, if you're dealing with a US entity, how do you go about it?
We usually prefer a neutral jurisdiction and neutral law so that it's not partial for both the parties.
Okay.
So, yeah.
How does it work? How does it work?
Well, people do agree. I mean, we've had agreements to that effect that we have proposed Indian laws, they have proposed, say, Boston, Massachusetts laws, and we have negotiated that let's have a neutral jurisdiction of, say, arbitration in Singapore. And they have come around considering the the ease of arbitration in Singapore, and they're aware of it. Yeah.
Good. So this is going to get very common eventually with this global trade, and now we're part of global economy, and we all are global citizens in a way that you deal with overseas entities. And when you are collaborating with someone where the stakes are high, it is important for you to understand and This is the theory part, but I'm just going to have only 2 comments to offer on this. Unilateral is the basic framework that globally has been adopted by most of the countries with whom we trade. India trades today, and thanks to unilateral, regulations and the framework, that the way we negotiate contracts, the way we write contracts, the way we go and takes a resort to international disputes. So tomorrow, if I want to go and claim certain damages from a US entity versus a Singapore entity, all of that has flown down to us from unilateral. So that's just the baseline for us. But the first and foremost, when you are negotiating a collaboration agreement, always try and incorporate something called as alternative dispute resolution. So it could be in the form of mediation, it could be in the form of arbitration, and then as a last resort, you go for litigation. In the absence of those clauses that you would write there are chances that if tomorrow there is a dispute, you will directly get dragged before the court. So, alternative dispute resolution at least gives you that leeway to first have some, out of court conversation with the other party to see whether things can be resolved. Now, how many of you are aware about this concept of arbitration? Have you heard this term before? Right. Arbitration is another good method of closing any particular dispute. And there are 2 types of arbitration. One is institutional arbitration and another is ad hoc arbitration. Ad hoc is where you actually go through the current law and the regime of Arbitration Act, and institutional arbitrations is where you have certain institutes, they have got their own set of rules, and Pune has got ILS Law College, and there they have ILSCA. Delhi has got good arbitration centers. Every other city in India is now coming up with its own set of arbitration centers. It's always more viable to go for those institutional arbitrations. And I think I do have some examples here. Singapore International Arbitration, AAA American Arbitration, these are international arbitration. Bombay Chamber of Commerce is one of the very well-known and old institutional arbitration. You could actually add those clauses there. Those are easily available on their websites. They have something called as model arbitration clause. You just go and copy paste that, use that, because you otherwise will have hard time to directly get dragged before the court. This will slow down that pace, and at least your chances of trying to resolve that dispute out of the court will be high. I think this is a question that we discussed, that if you're an Indian entity, as an example, you're dealing with a US entity, which is company B, then which laws to prefer? Of course, as an Indian entity, you will always prefer to go with Indian laws first, with the courts of that city where you belong. I think the example that we were discussing, if you're in Pune, then you will say the laws of Republic of India with the courts in Pune shall have exclusive jurisdiction. But if the client or the collaborator doesn't agree, then what happens? Then you go for some sort of a neutral place like Singapore, Switzerland, English laws. These are some of the neutral places where a US entity would still be comfortable to try and resolve that dispute using those laws. So neutrality is another way in which you can negotiate. I'm going to talk very quickly about some of the commercial aspects when we talk about collaboration. IP ownership, Dr. Premnath was mentioning, is one of the key aspects. If you happen to have your own IP, which is developed, built in the background, that you're going to use it as a part of your collaboration, then that becomes a background IP. And if you deal, you with your collaboration partner, come up with something new, or as a result of your services, if you deliver something that will be treated as a foreground IP. And there is this concept of works made for hire. This is prevalent in different industries. Software industry is one of them, where you hire someone to develop certain pieces of codes for you. And then what gets delivered to you, the ownership belongs to you. And that engagement is called as works made for hire. So background IP and foreground IP. Now joint IP, before this session started, we were debating on this. This is a hazy concept. And generally, as a part of collaboration, as a lawyer who practices in this area, I don't recommend you getting into the conversation of joint IP ever, if it is possible, because it comes with a lot of complications, especially in the context when you're going to do your mergers, acquisitions, sell-offs, etc. This becomes a bottleneck for you. Now, my basic question to you is, when you're entering into collaboration, would you sign up for a perpetual agreement, or you sign for a very specific agreement which has got a 1 or 2 years term? What are your views? Anyone? Which one is better for you? Signing a fixed term? Why? Any specific reasons why you should look at only a fixed term agreement? What are the benefits when you are entering into a collaboration with someone? Why would you want to just have 1 year term, and every year then there is a headache for you to track that renewal and then again talk, and there could be some changes in the motivation. They might come, the other party could come up with some numbers. It's like your yearly appraisal otherwise. Or if you have any views?
A fixed term is obviously better. It is for a definite period of time. You're creating your rights and obligations for a definite period of time. Beyond that, say 5 years. After 5 years, the contract expires, your rights and obligations expires. Neither I am liable, neither the other party. If it is definite, then any day he may come up that you have committed a breach, which I might not know. So rather than in case of patents, for the life of patent or the term of agreement, that way.
Okay.
So a definite term.
Any counter view to this where you don't find any harm if you sign an agreement which runs in perpetuity till it is terminated, valid until terminated? That's the terminology that they use in the contracts. What is the harm? You sign an agreement, the rights and the obligations of the parties will kick in momentarily for that particular situation. You can actually frame that agreement in a way that whenever there is a commercial utilization of the part, you have some work order signed, but you have one long-term engagement kept there, and that agreement is not triggered until there is certain situation. But those rights and obligations are there on the paper. They do not run in perpetuity. You can cap them. Again, these are the two different sides. It all depends upon where you want to go, what you want to achieve. If you have signed something where that agreement runs in perpetuity, there is no harm, as long as you are able to contain those risks by having certain clauses in your agreement which limits your and the other party's exposure. That's what it matters at the end of the day. For many,
also,
yes.
Also, when it comes to exclusivity of contracts, if it's on a non-exclusive basis, unlimited is fine because I can deal with multiple buyers. But if it's an exclusive license given to an entity, you need to have certain time. You can, see if the business is going on well, if it's doing justice to the innovation.
I do have one use case for exclusivity. You're correct. That's how it works.
So, because some sort of a monetary improvement on a year-on-year basis or a periodic basis, then it's always preferable that we review the terms on a periodic basis rather than have it in perpetuity with one set of clauses.
So you're saying that the price escalation clauses?
Price escalation, yeah, or sort of, reviewing the royalties after a certain period of time or after achieving a milestone. Something of that sort.
True.
So adding to that, suppose if I'm not talking about the license agreement, I'm talking about the collaboration agreement. Suppose if the terms and conditions which we have mentioned and which are not working in our favor.
Right.
In the first year, I think this is the testing case for both the parties. So it's better to go for a fixed term initially. And if you found it is working very well, then you can extend it.
Yeah, that's.
You can review it. You can.
So there is also another clever hybrid model where they say that initially the agreement will be valid for 1 or 3 years, and then year on year, unless terminated, it will get automatically renewed. So here we are talking about a fixed term with a perpetual effect unless terminated at the end of every year. So you still get a right to put a full stop to that conversation if you think the relationships are not working fine.
Because it happened in our case.
Yeah,
because the
quite
terms
possible.
and conditions were not working in our favor, then we decide to terminate that. But
quite so yeah, it all depends upon the underlying commercial factors that you need to address in that contract. So of course, having an end to that conversation always benefits.
So Nihal, I just have one question related to your foreground IP.
Yes.
So background IP in collaboration agreement, we don't have any problem. But in case of foreground IP, you mentioned that about joint ownership.
Yes.
So what are your views on how to settle down? Because see, in case it will be unfair to the other party if we give ownership to other one person. And suppose if that contract is terminated in between, then it will create a lot of problems.
No, the concept. So,
On the foreground IP.
of course. So, foreground IP definitely is a clear concept. My observations were on the concept of joint IP, where it
Yes,
comes
so
with.
how to solve that problem instead of joint IP? What will you prefer?
Of course, I would prefer to have a foreground IP where you have a clear line drawn that what I'm working for right now will at the after a particular period will belong to you. It will get assigned to you. Of course, you can still retain the background IP and give a license of your background IP if it is required for proper working of the foreground IP. But that's how you should go about it.
But suppose that foreground IP is not dependent on the right, it is an independent.
Then there is no issue. Then I think it's all the more better for you. Now, if your question is in between the process, if you want to terminate because you are not motivated enough to deliver that foreground IP, then there has to be contractual factors or measures baked into that contract to ensure that if one of the parties pulls the plug in between prematurely, then what are the commercial impact of those conversations? So the parties will have to as a part of the effect of the termination for convenience and termination for cost. So what you're discussing right now is for convenience, where one party says, sorry, I'm not interested to work for you as a customer or as a partner. Fine, you get a right to do that, provided you agree for a longer notice period so that I get another replacement in the market. And if I want to suffer losses because you pulling the plug prematurely, then you'll have to write that clause in your contract to say you'll have to pay me those monies that I would suffer because of you prematurely terminating that contract. On the other hand, termination for cause is a clear concept where if I do not perform my services the way I'm supposed to do it, then the other party gets a right to terminate that contract. So that's a termination for cause.
Not having the topic for joint development. In case of collaboration agreement, obviously the background IP and foreground IP, these two sections are there. Right. So in case of foreground IP, we have mentioned that avoid joint ownership. That's what I'm trying to.
I think her question was, what happens if you prematurely terminates when the other party is supposed to deliver, foreground IP? Is how I understood.
No. That's what. That was not my question. My question is exactly how will you deal with the foreground IP ownership if it is not joint IP?
I understood in the sense. Yeah, I'm sorry. I understood in the sense of where there is joint development, which is also a collaboration. Joint development, wherein both the parties have contributed to create a foreground IP, which is to be jointly owned by both the parties.
Okay.
And that will the foreground IP itself is a joint IP.
Okay.
There.
No, there it's fairly complex. It all depends. Then of course, you'll have to hire me and somebody else to fight those cases out, and then see as to how it goes, because it will be fought on the merits of your contribution, right, and your investment, and whether you're able to still segregate those IPs individually and make them work, in isolation, which generally is not the case when we talk about joint collaborations. It's not easy. So that's why lawyers generally they hate this concept of joint IP as a concept, because it gets into a different angle altogether. Now there is this new concept which is emerging, is called as lien on IP. If you do not pay, then I get a right to, I'll have a right or a charge on your IP. That's how generally people write, where they say that I don't care what you have delivered, because you have not paid me and I'm the one who is delivered. You will not get the free benefit to enjoy that IP. It's called as a lien on IP. So these are what I'm discussing here right now are the ways in which you can address the non-payments. If tomorrow there is a delay, or if the other party does not pay you, how do you go about it? You can actually have some of these clauses added there. Of course, delayed payment interest clauses and suspension of services, termination, those rights are always there. But do they work? Not all the times. And therefore, this concept of lien on IP is something which is new that US is using fairly well right now, where most of the US collaborators use this concept where they say that if delay, I get a right to have charge on your IP. When it comes to anything to do with joint collaboration sort of a situations, you would always want to have a right to audit because royalties and how they're paid, generally there are chances of some misappropriation. It could be error or it could be misappropriation. So you having a right to have a good control as to how you're getting paid, what is the basis of that payment is determined by having a strong audit clause. So you should always have an audit clause added there. So let's say you have taken my assistance to create a derivative work on your IP, right? I've been working on it for 1 year. I have come up with different versions, and now that IP is ready to be utilized and monetized in the market. If I have a clause in my contract which says, unless you don't pay me, you don't get a clear title. It's like creating a charge on the property, right? If there is a mortgage sort of a loan situations, the bank create a particular charge on your property that unless and until all the principal and the interest is paid back to the bank, they'll have some charge on the property, which is a tangible asset. Similarly, in the IP context, you can create a charge on the patent, copyrights, trademarks, anything. So that's how you create a lien, a charge on that IP. So that could act as your contractual risk mitigation technique if tomorrow there is a non-payment. Non-payment of your royalties, your remuneration, whatever monies that the other party, your collaborator owes you, if there is a default in that, if you have this clause, then you can use that to your No, but you could also be a licensor. You could be an investor. It could be anybody. I'm discussing in general when we talk about collaborations. If you are supposed to get paid some money and if you're not got paid, how do you deal with it?
10 minutes.
Yeah, sure. So we'll circle back in 10 minutes. We have 10 minutes to go, or we have got a 10 minutes break. Sorry.
Actually, we are almost at the time.
Oh, is it? Okay. I think I'm almost done. Yeah, I'm almost done. How do you deal with acceptance sort of situations? Have you ever come across acceptance clauses in your agreements or the licensing arrangements? So when you deliver something to the other party, how do you determine the quality of those goods and services? What is the best practice to go about that? What happens if the other party continues to keep it very subjective and then they say that, sorry, I don't like this deliverable that you have given it to me. So generally the collaboration agreement should very clearly spell out as to what will be the objective test of your deliverables to the other party in the collaboration. If it is not there, it's a guaranteed delayed conversation that you're signing up for. So generally we recommend that in collaboration agreement, you build those acceptance criteria and you say that if the other party does not give you that acceptance within a particular time, then it will be construed as deemed acceptance. I think we spoke on exclusivity earlier, but I think this is relevant and I'll just cover that in 1 minute. If you happen to sign an exclusivity arrangement with the other party, there are certain pitfalls and there are certain advantages. I think the advantage is you get a fixed, focused growth because you're sort of engaged with that party on an exclusive basis. Both the parties generally, when they sign up exclusivity, are invested in that particular relationship. They do get sometimes a competitive advantage because they both could come from a very strong industry background. Their presence could be good. And if two parties are collaborating exclusively, then the chances of success are very high. And then the decision making becomes very easier. But there are certain pitfalls also when we talk about exclusivity. You could curtail your market growth if your partner is not performing the way he or she should have worked or that company should have delivered. You lose the competitive disadvantage many times because there are performance issues with your partner, with your collaborator. There is also a heavy.
It's not working and it's audible.
Oh, is it? This is not my mic. I've switched it off. No, I think we're good. Yeah. Okay. So I think the important disadvantage of you getting into an exclusivity is you lose the agility that you would otherwise get as a part of that relationship. I do have one use case that I have recently dealt with where, I was representing a company who has got a tissue engineering component, which is a patented component, and they also have got certain material and processes patented that is used to reconstruct certain bone tissues. Now, our client got two different offers from different pharma companies. One of the pharma giants said, I will invest in your company, I will collaborate with you. You give me a perpetual, irrevocable license to further develop your material. I will mass produce that. I'll go in the market. I'll sell it. Whatever I sell, I'll give you 30% of that. On the other hand, there was another competition of the same pharma company who is also a large pharma giant in that industry. They said, I will give you 50% on the same terms. You give me an exclusivity. So we have two competitive offers. One says perpetual license, irrevocable, non-exclusive. Other one says same terms, give me exclusive license. Which one is better? The other party is paying 50%. The first is paying 30%. Exactly. So the non-exclusive deal is always better because you can go and deal with many other such collaborators. Last 1 minute on insurance, because you talked about it. Only if you think that the other party does not have deep pockets to pay if tomorrow there is an issue. Generally a startup or an inventor who does not have that capacity, you contractually can agree and ask them to please bear the cost of premium so that they can buy insurance, so that tomorrow if there is a claim on you because of them, then the insurance company will pay for it. And there are a variety of products. I'll not cover those right now. But these are not deal breaker clauses, but these are good to have clauses. You can contractually also limit the collaborators' ability to deal with your competition, not hire your resources. These are called as restrictive clauses. And there are a bunch of those which are available. So depending upon your motivation behind that collaboration, you could limit the ability of other party to do certain things. And these are enforceable, except some of the provisions where we talk about the employee's engagement. Publicity, I don't think it is important. I think this is the last slide, and then we'll close this conversation. So when we talk about successful collaborations, I think what is more important is you please enforce those contracts on the ground. What it means is you reading those contracts, you having your different stakeholders in the ecosystem read those contracts, extract the important provisions which are relevant to them, because they need to actually practice those clauses on the ground when they deal with the partners. If you happen to have your partners where they're working on certain time-sensitive matters, please ensure that you add certain service level agreements and the penalties if there is a delay, if there is any issue with the quality of the services, or they're not able to deliver within the set parameters. If tomorrow there is a breach, then you negotiate and agree for something called as service level credits. So these are some sort of additional performances that they will do for you without any additional cost. So that's another way of you getting compensated without going to the courts. Please establish certain escalation matrix within your organization as to whom the issues will get escalated if you're not getting the cooperation from your partners. I still find as a lawyer today, the minutes of the meeting are highly underrated and they're boring for people to follow, but they do carry a lot of evidential value. People don't take efforts to document what they have discussed with their collaboration partners. Ensure that you and your team members document every conversation which is important over emails. Let that be captured and confirmed by the other party. If you happen to be someone who is required to shell out the equities, don't do that early in the game. because if you shell out a lot of equity early, then you lose your ability to have a good control. Eventually, you're going to suffer a lot of hardships. Do consult legal professionals or any other advisors who have got understanding about collaboration. And the last part is you need to have a clear communication. That's the key to your success. So I think that's about it. I'm happy to answer any questions you may have. We're good.
As you mentioned, in federal law, there is no indemnity clause.
No law has got any indemnity. Indemnity is in the contractual
contract. It's not applicable in federal.
Indemnity is a technique or a contractual protection to draw your own comfort that you could put in any contract with anyone.
During the presentation, it will be
No, federal government contracts. So when it comes to
government.
when it comes to government contracts, no government is going to come and give an indemnity. Yeah.
That's there with Indian government institutions also.
Government is there, not in private. Government is all over mostly. They are not so willing to have indemnity.
And they can't. They themselves are fairly, got into convoluted conversations. So. Okay, if you have any questions, my email ID is here. Feel free to write to me. I'm happy to write back to you. For any questions you may have, feel free to just write to me. You just mention the reference of today's session, and I'll be happy to get back to you.
Thank you, Nihal, for a very interesting talk. I will now request Nihal to give you a small token of this.
Thanks.
So we break for a short tea break. Tea and coffee is outside. Please join us. We can take a short one. Yes, yeah. And also request the next speaker to please close their presentation.
Desktop. This one? My collaboration agreement. Yes, okay.
माइक इधर से आके बोलो चेक करो